statement. So I'm going to start out by reading the Ethics Act statement. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. And so to get started, we meaning Mary, Brian, and I were talking about going through and letting everyone do a brief introduction. I know a lot of us probably know each other, but it doesn't hurt just to give your name, district, what type of law you practice. And the other item is that if you have ever offered unbundled legal services or have seen that happen in your area, if you could just speak to that briefly, just what the experience was, what it looked like. We have a lot of family lawyers on here, so going to be some overlap maybe between us, but maybe not, because we're all in very different counties. So I'm going to start. Catherine Fry. I'm a counselor from the 10th District, Wake County. I practice exclusively family law. As far as my experience with Unbundled, this wasn't necessarily mine, but for contempt issues in family law, judges will appoint a court-appointed attorney. And we have some situations where people will show up to court, they will have a private attorney and a court-appointed attorney. And I have seen that create a lot of chaos when you're trying to do a hearing that maybe has multiple issues involved. And so that's been what I've seen in Wake County as a common occurrence. And so we're just going to go, I'm going to go on my screen and just pop to the right and let Mary go next.
Hi, Mary Irvine. I'm the Executive Director for the North Carolina IOLTA program here at the North Carolina State Bar. And the only experience I know of with, kind of personally, with providing unbundled legal services is in the short stint of time that I was in family law before coming to the State Bar, and that was really only in the realm of document preparation. No actual making an appearance before the court, but just document preparation to help folks that were filing for custody or divorce. So,
excellent. Thank you, Mary. Brian?
Hi, I'm Brian Oaten. I'm one of your other co-staff counsel for this subcommittee and the Ethics Council here. My only experience with unbundled services is not personal. It's just in the experience through the Regulatory Change Committee and talking about limited scope representation and how that really serves as a foundation for a lot of efforts that can be made to try to give folks access to services that they might not otherwise afford. I've tried to limit the scope of my representation in my current job, but Alice never lets me. So she's on the call though. She can answer that a little bit later. Thanks, everyone.
Thanks, Brian. And just so you both know, Mary and Brian are staff liaisons, and they do 95% of the heavy lifting to get us ready for these meetings and to sort of walk through this process. So we are appreciative of their help and support. Next, I'm going to pop down to Ashley.
Ashley Campbell at Legal Aid of North Carolina, and I've never done an unbundled legal service.
Thank you, Ashley. Dion?
Hey, I'm Dion Fortner from the 13th Judicial District, and I practice family law. Where I see it mostly would be often because of our clients' priorities or because of money limitations. There may be an attorney involved in the custody case, and then there may be a separate action or even within the same action an equitable distribution claim. And often those folks are going solo on their ED claim, which is makes it a little hard when you're talking to your own client because you're doing kind of the heavy lifting for both sides sometimes when you're the sole ED attorney. So that's where I've seen it. And, I don't know how allowable it's been, but we allow it to happen.
Thank you, Dion. Dr. Rice, and tell me, do you prefer Dr. Rice, Darwin? I want to.
I'll answer to either one. Both are fine to me. So, as you said, I'm Dr. Darwin Rice. I am with the 26th Judicial District. I'm the Family Court Administrator in the 26th Judicial District. So I've been around family court for about 23 years. 14 of them was working in the state's only self-serve center. I've been around unbundled services and recruited attorneys for unbundled services since 2007. And we still have our program that's going today for unbundled services.
Thank you, Dr. Rice. I have no doubt that you will have a lot of unique experience and wisdom on this topic based on how long you've been doing this and the self-serve clinic that Mecklenburg County has run so successfully. Jennifer?
Good afternoon, everyone. I'm Jennifer Lechner. I'm the Executive Director of the Equal Access to Justice Commission. I've been working on unbundled policy issues for about 20 years now. I've almost always, my whole career, been an Executive Director of an Access to Justice entity. And this is an idea that has waxed and waned in popularity. And so it's making a resurgence here in North Carolina. I'm glad to see it. We also do unbundled services through the commission, through the Wake County Legal Support Center on our family law matters, and a number of our pro bono projects. So I'm pretty familiar with how it can work.
Thank you, Jennifer. Again, also your experience will be very helpful as we navigate this. All right, Daryl, you gonna tell us your story with the guitar in the background?
It's just a prop. No, I'm Daryl Davidson. I practice in Iredell County and Alexander County, and I do family law and criminal law, which is sometimes the same to me. As far as unbundled services are concerned, and every now and then, I didn't even know what unbundled, services were until the last meeting. But I guess I've sort of dabbled in it a little bit when somebody comes and they've got the custody worked out either through DSS, but they have this ED action that they need to file because they're trying to separate or divide property. So that's the extent of it. We don't offer it in our county. I noticed in Mecklenburg County, they have a self-help type deal, but we don't offer that here. So the only unbundled would be anything that an attorney here would say, okay, I'll take it separately. But you really don't see that a lot because everybody wants to have everything at once.
Mm-hmm.
And good afternoon.
Thank you, Daryl.
Mm-hmm.
All right, Gina.
Hey, everybody. I'm Gina Morris. I practice family law in Mecklenburg County, have for 30 years. I was involved in some of the drafting of the original documents that we use in our pro se self-serve center. So a little bit of involvement with documents, which is sort of lower hanging fruit to me than unbundled legal services where lawyers are coming in and doing a one-off. I certainly did it back in the day. I got stuck a couple of times. So I have the sort of the other side of the story. But that's on the judges. So if they commit to letting people out, then I won't have a problem with it. But I have not done it probably in at least 10 years, probably 15, maybe longer.
Thank you, Gina. Alice? You're on mute.
Sorry about that, Catherine. So I haven't been a real lawyer in over 30 years. Right now I'm a pettifogging bureaucrat. And I try to unbundle my work often by giving Brian things to do. But I guess my experience with it back in the day when we didn't call it that was in doing estates work for folks that were really, they couldn't afford a full estate plan. So you would let them know what you could do within a certain price range, usually a simple will, but tell them there are other estate documents that they might want to consider having at some point in time. So, you would try to focus on the critical thing that they really needed to have, and then make sure you referenced other things that would provide sort of a full service, but make sure that, they got what they could afford to.
Thank you, Alice. Marcy?
Hello. First of all, thanks everybody for serving on this committee. This has just intrigued me for a while. Anybody that would listen, I've said something about it, and I first learned about it through from some Florida folks because they're doing it in Florida and have been for many years, and so it just kind of intrigues me as a potential way to help those who can't afford to pay lawyers to run the whole gamut of their case. And really enjoyed talking with you, Dr. Rice, at the last meeting and finding out more about your, what's it called? What's the formal name for your center?
Self-serve center.
Self-serve, that's right. And then I also got a tour of the one in White County. Judge Dunstan gave me a tour of the new one in White County that opened, I think, just last fall. Is that right? So it's brand new. And then I'm very excited because we're having a meeting with Jennifer and others soon about possibly bringing that to Johnston County. And so I do think the unbundling within these self-represented service things are very important. So I'm excited. I'm going to learn. I'm here to learn. Thank you, guys.
Thank you, Marcy. Matt?
Thank you, ma'am. Matt Smith, Vice President, Resident Sidekick. I am just happy to see something being done through this committee, some low-hanging fruit, as I keep calling it, something I think we can act on, and it is my hope we can act on and do some quick work on this to get it out there so the lawyers can use it. Unbundling, I kind of like Alice said, estate stuff, real estate stuff. They unfortunately go hand in hand sometimes, so you get sucked into an estate even though you didn't know you were going to. So some parameters and some great things like that I would like to see. Thanks.
Thank you, Matt. Mark?
Thanks, everyone. Mark Henriquez, appreciate the chance to join. I'm an advisory member of the council. My exposure to unbundling came as I was chairing the committee to study regulatory change. We learned about it as an option to try to increase choices. So I'm really excited to see the subcommittee and talk about ways to move forward. I think that's great. I do business litigation. So unlike many of you, I'm not involved in the type of unbundling we're talking about, although it occurred to me, we do narrow scope engagement letters all the time saying we're going to represent you, client, on this narrow issue, either this litigation or this deal, and we disclaim a bunch of other stuff. We're not going to give you tax advice, or we're not going to give you business advice or keep you alert in other areas. So even in the business world, I think it's common practice to have a closely defined engagement. And so I think, we're happy to talk about how we do that, but I think there should be opportunities to do that here and give, an opportunity to provide important limited services without being drug all the way in on every issue.
Thank you, Mark. I like that. Appreciate that perspective from the business world. Last and certainly not least, Todd.
Good afternoon. Like Mark, I have spent 36 years on the defense side, corporate defense, and I was sitting here trying to recall. I cannot recall a single case where my corporate clients have hired me on a limited basis. They typically say, here's the case, and defend it. So I have not done tons of unbundled services, but as the fellow officers and Alice know, we are going out from time to time and talking to these various judicial districts. And one of the things we are telling them is that we are studying unbundling legal services. And so I am very, very interested. I've read some of the articles and very, very interested to follow this committee and see where we end up, quite frankly, because I think it has a ton of promise for access to justice and other issues, quite frankly. So I want to be listening to what you guys do as you do your good work going forward. So thank you for having me.
Thank you, Todd. So moving through our agenda, the next item is just reviewing specifically what our charge is. And I just say that so that everyone can remember the court that we're playing in. There may be other things that come up, but we want to stay specific to our charge. And our charge is to study and consider drafting a proposed amendment to Rule 16 of the General Rules of Practice for Superior and District Courts, so that it can be submitted to the Supreme Court with the goal of facilitating increased access to justice through expanded limited scope representation of clients. And so on that, I think Daryl made a good point. I don't want to get ahead of ourselves. So I don't know if Brian or Mary want to talk about exactly what does unbundling legal services mean?
Yeah, I was going to take that, Catherine, just to kind of make sure we're all on the same page. And then Mary has put together your agenda with a lot of materials, particularly a lot of materials from other states. And I'm going to kick it over to her and let her explain all of the work that she put in and really what's at your fingertips. But, you know, and to Daryl's point, you know, I think a lot of us hear these terms, unbundled legal services, and we're not sure exactly what we're talking about. And so we just want to take a moment to make sure we're all speaking the same language. Unbundled legal services, you see there in your agenda. There's some articles from the ABA. The ABA has endorsed this idea, and you know I think it's one of those things that this is an idea that perhaps a number of us on this call, and certainly a number of folks in the profession, have already experienced. You just didn't know you were doing it already. Unbundled services is just limited scope representation. It's the ability to essentially dissect a representation into discrete parts. And it allows, I guess, if you unbundle your services as a lawyer, you are then permitted to represent a client in a very limited manner. Classic example would be, you know, say you have a family law matter, you've got a domestic case, and you're going to take someone through discovery. You're going to represent them only at a deposition. Things of that nature. There may be discrete tasks where somebody is appearing pro se. They cannot afford a lawyer for the entire thing, for the entire representation, but they can afford someone, and they really need somebody for one particular part: mediation, deposition, etc. The thing that we run into and why this is an issue is not because lawyers can't do that now. Lawyers can offer limited services now. The rules of professional conduct permit this under Rule 1.2, that a lawyer can offer limited scope representation if the limitation is reasonable under the circumstances. You know, so there's some thought that needs to go into this as far as a lawyer actually providing limited scope representation. But what we run into is, and I'm going to go ahead and share my screen just so we can see the language together. Rule 16 of the General Rules of Practice. Quick thumbs up, or you can see Mary. Are we good? Okay. So Rule 16 is what we have, and this is in your agenda if you want to go take a look at it yourself. But Rule 16 of the General Rules of Practice states that no attorney who's entered an appearance in any civil action shall withdraw his appearance or have it stricken from the record except on order of the court. And this was something, you know, you see there that basically it confines a lawyer. You know, if you're going to become the attorney of record, you can only get out of this if the court permits you to. Now, many situations, a court is going to grant that motion to withdraw. You can say, hey, judge, I was only supposed to be here for a limited scope. I've completed that task and I'd like to be let out. And you know, sometimes, maybe even most times, a judge is going to agree with that, but there are going to be times when a judge does not agree with that. And it's going to be dependent upon the circumstances. So the question then is, should this rule change? And if we change this rule to allow, as opposed to requiring the court to let an attorney out, that there's a mechanism that a lawyer can enter a limited scope representation, and the presumption becomes that lawyer gets out of the case at the conclusion of the limited services. That might switch the calculus, so to speak, for a lawyer that's looking at some sort of request for limited scope representation. The fear now is that, hey, you know, the client comes along and says, can I retain you for to just get me through discovery? You know, hopefully we can resolve things by then, but you know, after that, I'm not going to need your services, and frankly, I can't afford your services. And a lawyer might say, yeah, I could do that, but I am afraid of getting essentially connected to the case forever, indefinitely. And suddenly you find yourself trying to get out of the representation. The judge says, no, I'm not comfortable letting you out at this point. And you now, lawyer, have accepted representation for a lesser amount. And it becomes this thing where you're stuck to the case all the way through trial. And that is not what you originally bargained for. So the question that I think was posed, it's been posed in a variety of circumstances, whether it was the Regulatory Change Committee talking about unbundled legal services, it's these conversations with different jurisdictions. And Mary can talk about the different jurisdictions and the materials that you have out there, because I guess just kind of a spoiler alert, if you haven't looked at them, there's a lot of other states that allow unbundled services. But the idea is that if we empower lawyers to basically enter this limited scope representation, then perhaps lawyers will feel more comfortable taking on discrete tasks that really could effectuate a resolution of the client's matter, and just remove this barrier, remove this concern that a lawyer is going to basically accept representation and really payment for limited services, but then be on the hook for the entire thing. That's the access to justice component there. So again, unbundled services, it just means limited scope representation. It's something that is permitted by the rules of professional conduct. It's something that lawyers have done and will continue to do. But the question that's posed to this subcommittee, I think, is an examination of Rule 16. As it currently stands, lawyers have to get permission of the court to withdraw from a case. What other states have done is they have amended their rules to allow lawyers to enter notice of a limited scope representation that allows them to basically exit the representation at the conclusion of those limited services. That's the default. It changes the default of when the lawyer gets out and does not require the court's permission to exit the representation. Now, clearly, there's some nuance to that. There's some states that have some language about, that essentially a court can, for good cause shown, refuse to let someone out under certain circumstances, and we can get into all that nitty gritty. But the bottom line is that I think the question that we're looking at here is, one, do we think unbundled services would be a benefit, or creating some sort of structure that would allow unbundled services more readily available to lawyers and to clients? Would that be a benefit to access to justice in North Carolina? And if the answer to that is yes, how do we craft that? And that's where all the other materials come in. So that's kind of my introduction. Before we move on to the specifics, I kind of want to pause and just ask if anybody has any questions or if there's any clarification on the idea of what we're really looking at.
I have a question.
Yes.
May I go, Madam Fry?
Yes.
Thank you. In the states that have addressed this, do they have one rule that talks about withdrawal in a general appearance situation and a different rule that talks about withdrawal in a limited appearance situation? And it occurs to me that what we would be doing, we want people to have fee agreements, right? No matter what. So they would file a notice of limited appearance. They would have a fee agreement for the limited appearance. But what we would be saying in the rule is that the contract governs in a limited appearance, but it doesn't govern in a general appearance, because the judge still can trump your contract. And I wondered about how everybody squared all that.
Yeah, I think the overview of the states is that I'll say it depends on the state. There are some states that are very specific, and Mary, please feel free to supplement here where I get it wrong. But my review is that, yeah, there are some states that are very simple, and they just say it's not even so much the contract controls, it's the notice. It seems like they all pretty much require lawyer needs to provide notice to the court of the limited representation and exactly what the scope of the representation is, and then notice at the conclusion of those limited services served on all the parties. You get into the whole thing of, we were talking about this before the call, that some states have gone as far as addressing, which I think is frankly an appropriate thing, addressing when you are in for a limited scope and something else comes along. You're there for discovery and somebody files a motion for temporary custody or an emergency motion or whatever, and you get served on it. What are you supposed to do then as the lawyer with a limited scope representation? So that's where you get kind of into the nitty gritty of what does this look like? What should it encompass? But there's a real variety of rules from the other states. Like I said, some are very simple and others are a bit more complex. As far as the location, I see most being in kind of their equivalent of their rules of general practice, like ours is, and then some are in their rules of civil procedure. but they aren't really in the rules of professional conduct. Everybody kind of references, or many reference, their rules of professional conduct as this being a permissible thing as long as it's reasonable under the circumstance. So the limited scope that a lawyer is trying to get into still needs to be in compliance with the rules, i.e. it's got to be reasonable. But nevertheless, there's a fair spectrum of different options here. Mary, have I missed anything?
No, I think that's right. I mean, it seems like there's some that have just a rule that's only within the provision about withdrawal. There's some that have a sort of a provision within the appearance rule, a provision within the withdrawal, and then maybe they'll have another one that just defines it or adds in, you know, something about service or, but it's kind of all different. And I think you can tell the ones that are, there's some that are more specific. They've really made sure that anywhere it would be appropriate to mention limited service, because there's something that's slightly different or unique about it, then they kind of weave it into what's existing as like an additional subsection. Whereas some, I think it's like pretty broad.
I had a question.
Thanks. Yes, Todd.
You don't have to point them to me, Brian and Mary. Since reasonable under the circumstances is subject to interpretation, obviously, are there rules or opinions that we have put out as a state bar on 1.2C? Do we have any that are in print already?
Yeah, we do. I think that if we move forward with this, if this gets adopted by the Supreme Court, and that's kind of I probably should have said that earlier. I know we said this at the Access to Justice meeting, but the general rules of practice are under the control of the Supreme Court. So that's not something that we can change on our own. This would be more so if we think that there's something to be done here and we want to propose new language, we'd be proposing this to the Supreme Court. If the Supreme Court goes ahead and agrees with this, then I think that provides an opportunity for us to create a new opinion, or maybe even a toolkit that exists out there. You see, I think Mary, is it Illinois? They've got a toolkit that basically offers, you know, a great resource of what's considered reasonable. What do you need to do, you know, for filing the notice and all that. They have templates. There's some states that require particular forms, you know, so that might be a consideration here, that there's a specific form that lawyers need to fill out. So yes, to answer your question, we do have some resources. I think that, you know, they offer the general principle of what is considered reasonable under the circumstances. But clearly whether something is reasonable under the circumstances is going to be dependent upon the particular facts of the case. But I think in this context, this would offer us an opportunity, whether it's an additional or a new comment or an ethics opinion or a tool or a toolkit that would really help lawyers identify what is appropriate. I would probably suggest that course of action.
Thanks.
Any other questions? All right, not hearing anybody. Mary, I think you're going to take it over from here and give us some background on all the great information that you put together.
Sure. So I want to, I'm going to share my screen. You all received this link, and I just want to take a second and have us just kind of, you know, before we go into the specifics of the rules, kind of step back to this survey, which was done, which I think provides a useful kind of context here. This was an ABA survey that asked lawyers about whether they in fact were doing unbundling, and then asked them some questions about it. So can y'all see the survey that I pulled up? Okay.
Yes.
Unfortunately, there wasn't a way to like save this as a PDF, but their graphics are kind of useful. So of the folks that they surveyed, you know, 70% said they were not doing any unbundling. So that's a fair portion of lawyers that are saying, no, we're not doing any unbundling. There's another kind of good chunk here, 23%, that said that they were unbundling in less than 20% of their kind of caseload. And then these other 7% here are doing unbundling in something more than 20% of their caseload. So I thought that was interesting. And then to speak to why they don't unbundle, for the ones that don't, kind of the top answers that they gave about why they don't. They don't think that it would really work for their practice. They're worried about malpractice issues, or they think it would be difficult to get enough clients. And then opinions from those who do that speak to kind of, just kind of what they think about it. Folks said it does lower the cost of cases so that it can be more affordable. So again, kind of speaks to the reason why we're here. Maybe it can extend services to folks that otherwise would go without. That it also makes the services more competitive in terms of the price, and results in fewer uncollected fees. So I thought that was interesting. And just this last bit that I wanted to sort of make sure that we just kind of acknowledge, because I think that this was also highlighted in the resolution from the Conference for Chief Justices that was put out really just like a month or two ago, is that even though many jurisdictions have these rules in place to allow it, unbundling seems to not be utilized by very many people, and people don't know. Members of the general public don't necessarily know. Maybe they don't know to look for it or ask for it or know that it's available, or a lawyer might consider doing it. So it seems like there's a lot that can be done, to speak to Brian's point about a toolkit or court rules or additional ethics opinions. There's a lot that can be done potentially to encourage folks to really promote this, to give lawyers the tools, the information that they need to really be able to do this effectively and feel confident that they're doing it ethically. So this speaks to some suggestions that, greater guidance and clarity around their ethical obligations, around malpractice issues, around court procedure, that all those things would be important to the folks that responded to this survey. So that was the first piece that I wanted to share. Let's see. So we already talked a little bit about the North Carolina court rules. So I guess moving on to the other states' court rules that we pulled, you all saw that document with the sort of appendix at the front. I'm going to go ahead and share my screen, and I thought we could just walk through a couple of the rules to kind of highlight how they're structured. And then I will also try to highlight some of the things that we've seen in some of the other rules that we pulled. So hold on just 1 second while I share my screen again. Okay. So this is pulled up to Illinois. No, this is not pulled up. This is pulled up to Alaska, so this is not the one that we're looking for. Okay. So the rule in Illinois has been in place since 1982, but it was recently amended, which I think is interesting and maybe something that we would want to get some more information about at some point, because hopefully they're drawing from the experience that they've had over the years with folks providing these kinds of services, and are honing the rule to make that kind of even stronger for their purposes. This Illinois rule does require filing a specific court form to indicate what they've agreed in writing about what the limits of the representation are. And then it kind of walks through that the attorney can withdraw in open court or by motion outside of court, but both require the client and the other parties being given the opportunity to object via a specific objection form, which is, I think, also provided when that notice is given. And then this rule states that unless clear and convincing evidence that the agreed upon services have not been completed is provided, then the attorney would be released from that limited representation. Let's see. Yeah, so you can sort of see here this redlined version from the Illinois rule. Another one of the rules that I think actually the Access to Justice Committee may have already looked at was the Virginia rule, which also allows for limited appearance, and it indicates who receives the notice, who needs to be served and when. I define that specific part of the rule. Specifically says for the duration of the appearance, service of all papers must be made both upon the attorney who has made that limited appearance and also on the party on whose behalf the appearance is made. Which, you know, I think some rules specifically address it and some don't. So it seems to be that there may be some benefit to having the rule specifically address it, and maybe even in further specificity than what's here. So under the Virginia rule, they can file notice once the obligations are completed. A client signature is required on that notice, and then it's served on everyone, but then they're out. Automatically, they're out. If the client can't or won't sign that notice that the limited scope appearance is completed, then it's served on everyone with 7 days, opportunity to object. And then if there is an objection, there's a hearing to address that objection. And I think it's similar that if the court determines that the obligations have been met, then the ability to withdraw must be granted. So that one is a Virginia rule. I did think that this was interesting too, that they have, if the limitation on your appearance is that you are going to be in this hearing only, you're going to be sort of in and out, then your notice of appearance can also serve as your notice of withdrawal, kind of on that same form, if it's going to be all done within the scope of one hearing. So I thought that was interesting. Different piece that I don't remember seeing necessarily in some of the other rules. And then another one that I wanted to spotlight is the Michigan rule. I'm just going to get to the right place here. Yeah, so under this rule, one thing that I would say that's a little bit different is it does give some examples of a time when someone might appear for limited representation. So it specifically talks about depositions, hearings, discovery. I don't know that I cannot remember if this is one of the ones that that sets forth any situations where limited appearance would not be appropriate, but sometimes you see that in some of the rules, like I believe it was DC, not appropriate for a jury trial, that you would have a limited appearance. There's some other rules that do specifically prohibit in certain instances. And in this rule, you file and serve the limited appearance, and you have to be clear about that limitation, whether it's a specific date, time period, or kind of what the scope is. And the attorney must stick to that limitation, says it specifically in the rule, and they withdraw by filing a notice of withdrawal from the limited appearance. Similar to some of the other rules, if it's signed by the client, it's effective immediately. If it's not signed by the client, there is a sort of opportunity to object for a period of time. This was also, there's one provision in here, which I've seen in a couple of the rules, that you have to provide the service address for the pro se litigant kind of going forward as well. Just kind of an administrative piece, but an important one as a component of some of the rules. So those are the couple that we sort of pulled out to spotlight. I mean, I guess I'll say there's all kinds of different pieces in the rules. I mean, you see this is like an example of a form. In the California rule, they have a couple of different rules, and this one, you know, that starts with sort of the definition. What do they mean by limited scope appearance representation? So that's kind of laid out here. Some of the other pieces, Kansas, I saw had some interesting parts to their rule. Again, you have to be clear about what the scope is, what specific issues are covered by that appearance. They also have some language on here that has to appear on every single pleading, attorney for blank party under limited entry of appearance. So there's some things like that that appear in some of the rules that require you to use certain language, being clear about the limited scope on every single pleading. There also is a piece in this rule that says if you file something that's outside of the limited scope, then that constitutes a general appearance, which I thought was, an interesting piece that some of the rules also contained. So those are the ones that I wanted to specifically spotlight. We can stop here for a second. I did have just 2 slides that I put together to sort of highlight what I viewed as some of the differences among the rules. Just a couple bullet points that sort of show the different nuances that were noted. But I don't know if anyone has any questions first about specific rules or about specific pieces that you've seen that you want to talk about a little bit more here.
So Mary, I don't know that I have a specific question about the rules necessarily, but specifically for a place like Illinois, has anyone performed any analysis to see if this unbundling actually increases access to justice for certain individuals? Because you're generally sort of looking at lower, moderate income individuals who may not be able to afford an attorney, but you're also hoping that they have the wherewithal to know that they can get limited services. And so I just didn't know if any of these states, especially one like Illinois that's been around for so long, if they've answered that question.
Of the sort of general awareness that the public has about the availability. Yeah, the only thing that I've seen suggested that there's just not great awareness. There was another survey, and I'll have to find it and pull that back up. There was another survey that it was almost like once they walked the folks down the path, they said, "Oh yeah, no, if I knew that was available, I would want that." But there wasn't necessarily a recognition on the front end that that they understood that they could find an attorney that would just help them with this piece, and then they could do the next piece.
I'd be curious, Dr. Rice, I know Mecklenburg has been working with unbundled services for a while, and I know you started talking about that at the Access to Justice Committee meeting in January, but what's been your experience down there in the great state of Mecklenburg?
Well, I would say we do have those instances that Gina brought up. One thing we attempted to do, I like a lot of that. I like a form. I think forms that are in the file, I think those help. You go to court or the judge can look at the file and see, hey, they're very specific about how their services are laid out. We don't have that now, but we do have kind of a understanding. I was in a divorce matter that had 6 other matters along with it. So it was a live hearing. And one party was in Washington State. He sent an attorney. And the attorney stood up and said, "Judge, I'm only here for this one specific matter out of these 6 matters that are on this hearing for today." And so the judge said, "I got it. I understood." So when it came down to objections and the other side, she's like, "I'm not here for that. I'm not here for that." And so it wasn't even an engagement from the judge, but only on those matters that she specifically stood up in court on the record and said that she was the attorney, she was retained to perform this particular function for this particular issue. So it is something we try to do on the front end. We have 9 new district court judges here in Mecklenburg County. So we try to do an orientation to talk to them about it. But I think education is one big part for both sides, for judges and for attorneys. So I do promote CLEs and CJEs would be very important. So everybody's on the same understanding, within that county. So the next time Gina files one and she goes in front of one of the domestic judges, there's that shared understanding about when she can get out of it and when she has to stay in it. Because that attorney made it very clear what her role was. And she did no other work. She sat in the hearing for 2 hours, but she did no other work other than answering questions specific to the issue she was hired. And the judge didn't require her to do anything else. There was no agreement. There was no piece of paper she provided to the judge. She just simply stood up at the beginning of the hearing and made that statement. And that's all the engagement that she had related to that case. So I think I think if we get to that point, but I think for the attorney side of it, making sure we have that form, making sure we have that that agreement to be as specific as possible, a form to get in, a form that you're out. We're hopefully going to be getting Odyssey sometime here in the near future across the state, and that would help having that form in the system. It will help everybody because the judges will see it, the clerks will see it, the family court will see it. Everybody will be able to see it in Odyssey. So if that document is filed with that party, there's not an issue about whether you're still in the case or whether you're not still in the case. The judge can look at it and say, oh, well, you were only doing this matter and you've completed that. And here's your notice of completion if we decide to go that route. And I think that would make it clear cut. But I think here it's just been that shared understanding in Mecklenburg County for the most part. For the most part, I haven't seen too many of them have an issue recently. Probably less than the 10 to 15 years that Gina talked about. But I would say a shared understanding, education on both sides, agreements on both sides as to how they interpret it and how they understand it.
That's
I
great.
had a question, Catherine.
Yes, Todd.
Observation, I guess. If we amend Rule 16, which is the charge of this committee, I just want to point out that a lot of the counties, I know Mecklenburg does, have local rules that speak to how you withdraw and what you must do. And I suspect Wake and some of the other counties have those same rules. And so I just want to suggest that as we look at this, we look at, to the extent we can, what the rules in the various counties may provide and see if there's some way that we may be able to also recommend some sort of uniformity and consistency that lawyers have to follow when they're withdrawing, so that, you know, they can sort of look to one source, maybe Rule 16 or the toolkit or whatever, without having to look at every single local rule in every county. And even if they do, it would be nice if the counties and those rules have some consistency that we might be able to bring to bear with the recommendations that we make to the chief and whomever.
Maybe Ty, we could work with AOC to get some forms. You know, that would be
Absolutely. Consistency and uniformity would be ideal, because it can get a little tricky, quite frankly.
Can I make a comment?
Please, Marcy.
Madam Chair. Well, actually, it's a question too for Dr. Rice. In Mecklenburg, do you use unbundling so lawyers can get out after temporary custody? And the reason I ask that is because in all the studies that we see, one of the big issues in terms of access to justice or custody in the domestic world is custody cases. So I know that family lawyers, you know, hesitate to take a custody case pro bono or for a smaller fee, because those cases can take a life of its own. I mean, they can go on for years and years and years. I'm seeing those faces on the screen that do family law, and they know what I'm talking about. So what I was thinking is, you know, lawyers that do custody work might be more willing to do custody, say, through temporary, you know, and to do it maybe even if not for free, but for a reduced fee or for free, if they could get out after temporary custody. And so, and then the client knows that they can get out after temporary custody, so they probably would be a little more reasonable than they have a tendency to be sometimes in these cases when it's very emotional. Have you done that in Mecklenburg County with temporary custody? Limited representation?
Not so much with temporary custody. Most of the time in custody, they're either ghostwriting the pleading or they come in after mediation prior to a trial. That's the cleanest way to do custody, because the middle is mediation, and that's, you know, within the state court. So they're not really doing anything with that. So a lot of times they may ghostwrite the pleading and the paperwork and say, okay, I'm done. But if it fails in mediation and you feel like you need a trial, then you can reach out to me 3 weeks after your mediation fails, a month after your mediation failed, and I'll look at what's going on and decide whether I'll take it on the back end. So they really don't do the temporary matters because it does get to be sticky. You have things such as service in there. Both parties don't show up, only one party show up. Are you still on there? If they just deny it, or what if the judge denies it but grants another hearing because the circumstances were, greater than what they want to just flat out deny it for. So it gets a little sticky. So most of the time it's just the pleadings and then trial at the end. Those are the two cleanest places, especially for custody.
And Marcy, it is my recollection that that is one of the examples of where I got stuck. I think it was before we have in Mecklenburg now temporary parenting arrangement hearings. That's a little bit like temporary parenting arrangement is to custody, as PSS is to alimony. It's kind of a whole different animal. So it is a discrete service for sure, but I believe that my experience was before that, and I tried to do emergency custody or temporary custody or a DVPO, and the judge did not want me to leave because of that. Now I will say two things. Number one, there's going to be an appetite among the Mecklenburg County District Court bench, I believe, for more help from lawyers, because the statistics about the number of pro se cases and double pro se cases that they're handling now are mind-blowing. And I'm sure Darwin could give us those. And so they would like one lawyer in a case, even for a minute, because it's going to make their lives a little bit easier. So that's one thing. The other thing I would point out about this form situation is, remember, I always like to praise the MOJ. The MOJ has language in it that says the lawyers are out when this thing is entered. So that is certainly something all of these lawyers are going to need to do an order at the end of whatever it is that they're doing, and they need to put in those orders that they're out.
I want to get to Jennifer, but the temporary custody is going to be sticky because we can have a temporary custody hearing in Wake County in 20 days. And then we also have a lot of judges who are infamous for giving reviews. So if you get in for a temporary hearing and then all of a sudden they want a review in 6 months, I mean, obviously if you drafted it correctly or very limited, but custody will be certainly a sticky wicket. But Jennifer, you've had your hand up.
Oh, it's okay. I didn't want to interrupt that conversation. A couple thoughts. One is just on numbers. So the Wake County Legal Support Center has been open since January 9th. It served its 1,000th visitor last week in just over 10 weeks. 70% of those cases are custody cases. So if that gives you a sense of the volume just in Wake County in 10 weeks, those of you who practice in that area know that that is absolutely true. It's also what the statewide civil legal needs assessment bore out, that family law is the highest need. But I also wanted to address Todd's point about local rules. The good thing, if there isn't, and I'm currently sitting in the AOC building, so hopefully they're not listening to me, but if there's a good thing about Odyssey, it is that there is no more local rules. So if your rule is good enough to be adopted statewide, it will be evaluated and adopted statewide. But individual jurisdictions will no longer have local rules. And so whatever this committee recommends to the Supreme Court, and should the Supreme Court choose to adopt it, that would be statewide and not subject to any local rules as Odyssey gets rolled out in all counties.
Interesting. And Wake is one of those, kind of like Marcy. We've got Odyssey, and I mean, there are pros and cons with everything. I think it's great if people know how to use it. If they don't know how to use it, then it sometimes makes things a little more burdensome. But it is, once you settle in, it's a nice feature. Mary, I didn't know if you had any more background, or Brian, that you wanted to talk about before we kind of get back to those threshold questions you had identified earlier. Brian?
Well, Mary, I think Mary's got some slides.
Yeah, and this will be super quick. This is just 2 slides, super quick, but I just wanted to sort of go through, from my kind of review of the rules, some of the distinctions that the committee would need to think about. Within the rule for withdrawal, does the court allow automatic withdrawal or some kind of application process? Do they have a particular form? Is there certain language that's required? In terms of notice, how are those notices of appearance and withdrawal handled? Who receives it? When? Does the client have to sign it? What sort of detail do they have to set forth about the scope? I feel like I even saw one rule that was like you had to attach your some portion of the agreement with the client to sort of show your work, I guess, that in fact the scope has been limited. And then is there an opportunity to object? Is there a specific form? Again, what's the time on that? And then I think more broadly, to go back to kind of one of the questions about, is it just a withdrawal rule or is there something else? You know, there's some other pieces here. Do they have anything in the rules that speak to kind of defining what limited appearance is, saying what is appropriate for limited appearance and what is not? Is anything specifically prohibited? Questions related to service. Do they also have a separate rule that's related to document preparation, to be clear? It's explicitly allowed, but it's not considered an appearance, or is there some sort of language that's required for pleadings with document preparation? So those are some of the distinctions that I identified in looking at those various state rules that we pulled.
Yeah, I think that's helpful. And I think kind of going to that question that I posed at the outset of, first being, do we think this is worthy of pursuit in terms of access to justice? Catherine, you asked that question of, is there a proof of concept, right? That this thing is actually reducing barriers and so forth. And I think what I have seen from various publications and so forth is that a lot of folks just don't know that it's there and they don't know how to use it. And so it's hard to say whether it is or is not working. Notably, and I said this in January, but I forgot to say it here at the outset, this is available in criminal representation. Criminal courts under 15A, you can enter this limited appearance for criminal representation. And that's something that's been a part of our statutes for some time. And so a lot of these civil rules, if you look at the date that they were adopted, there are some that have been around for 10 years or so, but a lot are brand new. Virginia being one of those. You see Illinois has just recently amended all those different red lines. That's a result of an amendment that just got approved in December of 2022. So there's still a lot of, I think, to Darwin's point, education and proper communication of this capability and how you use it and so forth, that really needs to kind of bear out, to see how effective it can be. But I think maybe that's a question. I know we're at 4:30 right now, but maybe that's something, I guess, if everyone kind of has a general feeling of, is this something we want to pursue? Is it worth, say, giving Mary and I the instruction, try to synthesize these rules and come up with some sort of proposals to serve as a starting point for a conversation? Because that's something that I know at some point, if we like this idea and we want to see what it would look like on paper, we have to put it on paper. So, but I think it would be helpful for staff to hear from the subcommittee whether you all think this is worthy of continued discussion and kind of vetting development.
Well, I don't know if everyone's as talented as Mark, who just did a big thumbs up. But if everyone wants to sort of raise their hand or somehow signify if they think that this is worth continuing on, I would want to make sure that we've sort of answered that question to mutual satisfaction.
I see a lot of raised hands and thumbs up. So
okay,
I think that's our instruction, Mary.
I'll say too that Catherine, I don't know that I really attempted in my mostly pull of the rules to see if there was any research on the efficacy. So if there is, I'd love to see it and show it to you all. So we'll do some searching on that too.
Yeah, we can do a more of a deep. I have looked into that. I'll tell you, I've looked into some of that, and it's just like, I feel like it's time after time people are saying they're seeing a reduction in the use of limited scope representation. They're like, people just aren't using this, and it's right here. So what do we need to do different? I think that's what spurred Illinois to create this toolkit with like a checklist of, how do you define it? Here's a sample agreement and all that. So I think maybe from here, Catherine, if it's all right with you, it sounds like, we probably need a starting point. So Mary and I can kind of try to synthesize things and start crafting something to discuss, unless you wanted to have another discussion of all these different rules to start picking apart which one do we like. We like this aspect, we don't like this aspect. I'd ask for some direction in that regard, if you want us to craft it or you want to have another meeting to really dissect all the different rules together.
So what I would propose, and if anyone on the subcommittee feels differently, please speak your piece. But I would say I would like for you all to use your best judgment in drafting a rule, and then it will be on the subcommittee members to review these other states' options to their, satisfaction, or just come up with other sort of concepts. We've talked about forms, we've talked about, different pieces, and just sort of give that some thought so that when we come back and look at a rule, you can determine whether or not that's been addressed, or kind of like what we talked about before the meeting got started. Who's kind of bearing the burden of things? Where does the presumption lie? So I think to the extent that the subcommittee members could do that, and the staff could come up with a rule, hopefully at the next meeting, we can at least start vetting what a rule would look like and get some more focus on where we may want to make additional changes. But anybody in the subcommittee sort of disagree with that proposal?
I don't disagree. I've got a question, because I had this question when you read the charge initially. Is the charge broad enough to draft the toolkit and all that stuff that we're talking about, proposals for Odyssey? Because it's very specific as I see it, which we're supposed to submit a proposed amendment to Rule 16, but I certainly would like if it's within the scope, to look at toolkits and other things that might facilitate how Rule 16 operates if it's approved by the Chief Justice.
Well, I think Matt created the sub and the charge, and so do you want to speak to that, Matt?
I think it encompasses all. If we need to broaden the charge, then so be it. But all matters related there too. It's kind of how I'm thinking.
Okay, Brian, you got your marching orders, and Mary.
Got it.
All right. Well, thank you all for your time. I'm going to try to be mindful and keep us at an hour. And I don't know, will we be meeting in April? Do you all know at the regular meeting?
Access to Justice will meet, and I think at that point, Catherine, you can give a report on this subcommittee, but we will not meet as a subcommittee probably till after the April meeting. We'll get something scheduled though, and we'll get on that as soon as that April meeting passes.
We have a very full April Access to Justice meeting.
Sounds good. All right. Well, it was a pleasure to see all of you. All of you take care and have a good rest of your week.
Thanks, everybody. Thanks for your hard work.
Thanks, guys.
Bye-bye.